Welcome to this Legal Aid New South Wales webinar on mortgage stress. My name is Bridget Barker and I am from the Community Legal Education branch of Legal Aid New South Wales. I'm here today with Lee, a solicitor in the consumer team at Legal Aid New South Wales. Good morning, Lee.
Good morning. Good morning, everyone.
Before we begin, we would like to acknowledge the traditional owners of the lands from where we are broadcasting today. I'm broadcasting from the land of the Widjabul-Waibil people of the Bundjalung Nation. We would also like to pay respect to the elders of the lands from which we're broadcasting, both past and present, and extend that respect to other Aboriginal and Torres Strait Islander people attending today's webinar or watching the recording. The purpose of this webinar is to give you an understanding of mortgage stress and where to get help if you or your clients experience it. During the webinar, we will use the term borrower when talking about the person experiencing financial hardship and mortgage stress. We will refer to the bank or financial institution who lends money to the borrower as the lender. I'll hand over now to Lee, who will explain what we mean by mortgage stress.
Thanks, Bridget. Now, mortgage stress is probably a term that you've heard of before, and in some ways it's a little self-explanatory. But just to be precise, I suppose it's a situation where that refers to a situation where someone's borrowed money to purchase their home. They have a mortgage secured on the title of the property in favour of the bank, and they have to make loan repayments over perhaps a 20 or 30-year period. And it's a situation where they may find themselves having difficulty in paying the home loan repayments when they're due. So there can be different levels of stress, of course, because they may still be making the payments, but they're struggling, or they may have already stopped making payments or aren't able to make the full amount. So we usually call it also, we refer to mortgage stress, the term is financial hardship. So it's where a borrower is in financial hardship and that is contributing to their difficulties in repaying the loan. So there are usually two reasons for financial hardship. One is that the borrower could afford to make the repayments on the loan at the time they took the loan out, but due to some unforeseen circumstances, say loss of employment, accident or injury, illness, or some other unexpected factor, it has changed the situation and they're having difficulty paying. The second situation is where a borrower probably couldn't afford to pay right from the beginning, and there's question marks about whether that person, the bank or the lender, ever should have given them a home loan in the first place. Now, today we're just going to be dealing with the first situation where the borrower could afford it when they took out the loan, but due to a change in circumstances, they are having difficulties now. If somebody is in that second category, then we suggest that they get legal advice about whether there's something unfair or unjust about the loan in the first place that may give them different sorts of legal remedies or recourse in relation to their position. And they should get legal advice about that, and Legal Aid does provide advice for people in that situation. And so, but today, for today's webinar, we're only going to be dealing with a situation where a person could afford it, and then a change in circumstances has led them to be either struggling or actually not able to pay.
Thanks, Lee. I'm just going to explain what we will cover in today's webinar. So for this webinar, as Lee has said, we'll be looking at financial hardship where a borrower could afford the loan when they got it, but their circumstances have changed after they got the loan. We'll also talk about what options homeowners have to vary their loan repayments, getting help from a financial counsellor, when to consider selling the home, and also repossession and eviction. So now we'll move on to financial hardship and the credit law, and I'll hand over to you, Lee.
Okay. The credit law applies to all states in Australia, and to all home loans, and it provides that the lender, so it gives some rights in relation to people who are in financial hardship, and that the banks have to comply with, and that is where the borrower has a right to apply or ask the bank when they're in financial hardship to agree to vary the loan or the repayment arrangements for a certain period of time, to allow them to get back on their feet, so to speak. And so the bank has to respond to their request for a hardship variation. And if they don't agree to the hardship variation that the borrower is proposing, they have to give them reasons why, written reasons why they're saying no. And they also have to give them notice that they have the right to lodge a complaint with the Australian Financial Complaints Authority. And we'll talk about that, AFCA for short, in one of the later slides. So one important thing to note about that situation is that all enforcement is stopped until after 14 days after the credit provider's refusal to agree to that request for the change in the repayment arrangements. And if the borrower lodges a complaint about the refusal in relation to the hardship variation, then the lender cannot take any legal action to enforce the home loan, the debt, until that complaint has been decided. So that can be a very important tool for borrowers when they're in a difficulty, as it can postpone the bank from taking legal action to repossess the home, and that's what we call enforcing the loan. So how does a borrower go about getting a hardship variation? Well, it's fairly straightforward insofar as they can either phone or email or otherwise contact their lender to ask for that variation, and the lender has to, under the credit code, has to respond, as we've discussed before. Okay, so, but there are provisos on what is considered an acceptable hardship variation. Okay, so before a borrower does anything, they need to work out why they're having trouble making repayments and what they can realistically offer as a repayment arrangement. I mean, they may be able to, there's a whole variety of hardship variations that they may ask for. It could include something like that they'll extend the term of the contract. So say if it's 20 years, extend it out maybe another year to make the repayments more affordable. Or they can just ask to delay repayments for a set period of time without extending their contract. So there's a variety of ways they can think in their circumstances what will be the best variation that's going to help them keep be able to keep on top of their home loan repayments. So as a guide, a repayment offer shouldn't be more than 50 to 60% of the borrower's income. They need to make sure they have enough money left for basic needs, and it's also important for them to note that they can also ask for hardship variations with other credit providers, such as if they've got credit card debt, or maybe even personal loans, or even with their energy providers, they can ask for a hardship variation also. So that's important to keep in mind. The lender doesn't have to agree to the change a borrower asks for. If the lender says, well, we see what repayment arrangement you're proposing, but based on your income, your circumstances, we don't think that realistically you're going to be able to make that repayment. Okay, so it has to be a realistic payment arrangement before the bank is obliged to accept that arrangement. So the next slide here we've got is sorry, one moment. Yeah, so it's an important question when thinking about being in financial hardship. One of the really crucial questions to ask, the borrower has to ask themselves, is this temporary hardship or is this long-term hardship? Because under the credit code, it really only contemplates a temporary hardship repayment arrangement. And if it's a long-term hardship, then a financial hardship variation may not actually be feasible or appropriate in the circumstances. And so they're generally short-term, the hardship variations. Most lenders will agree to 3 to 6 months initially, and often they'll review whether a further 3 to 6 month extension is required. So if the borrower is already in considerable arrears, like, you know, they haven't been making their payments for months or even longer, you know, and of course interest is accruing on these outstanding payments, then there's a question about whether the best way to deal with it is to actually sell the home. And that decision can be very difficult when, say, for instance, the borrower's unemployed and they're trying to get a job, but it's not obviously not clear how long that might take, or whether they're ill and they're unable to work, but they're not sure how long that will be before they're sufficiently recovered to return to work, or they may even be waiting for like a compensation payment. So in these situations, the borrower is hoping they can make loan repayments soon, but they don't know when this will happen. And the difficulty is that as time goes on, things are going to get worse, and they will get further and further behind on their loan repayments, and they'll incur a lot of extra interest. So in these circumstances, it's recommended sometimes that a borrower can make a repayment arrangement with the lender, say for up to 6 months. And if by the end of the 6 months they still can't make the loan repayments, they should put their home on the market. And then they go back to the lender and negotiate a further arrangement on the basis that they're selling their home. And a borrower should consider selling their home when they cannot afford the loan repayments and they will be unable to afford to pay them for some years to come. It's very important that they make this decision as early as possible, because it's better to sell the home themselves rather than have the lender take the home from them and sell it. A borrower is more likely to get a better price for their home, and they'd avoid a lot of extra legal costs if they sell it themselves, because if the lender takes legal action to enforce the debt, then all those legal costs are added to the debt. And so the homeowner, the borrower can actually be in a much worse off position than they would have been if they'd just bit the bullet and sold the property themselves. So it's best to decide before the lender commences any legal proceedings. Obviously, it's not too late to ask for time to sell, but the lender is less likely to agree later in the enforcement process. And as I said, the enforcement costs will be added to the loan. So that is also we recommend, and I think that this is a very, very good service, free service that's provided by financial counsellors, and we always recommend that unless it's very urgent, before the borrower contacts the lender to request a hardship variation, or decides to sell their home, it's a good idea for them to talk to a financial counsellor to work out which repayment arrangements are best fits with their circumstances. For example, if the borrower has recently lost their job but expects to find employment within 2 months, then the best option may be postponing payments until 4 months' time. So a financial counsellor is a fantastic resource available to people that can assist with this process and help to tailor a financial hardship variation or arrangement that suits the borrower's needs. And we've got on the slide there the Financial Counsellors Association, FCAN, and they have a search option where you can enter your what area you are in New South Wales, and you can find a list of the nearest financial counsellors to you. So next slide, where this is about the Australian Financial Complaints Authority, which we mentioned a little earlier. They provide a free independent dispute resolution process between financial service providers such as lenders, banks, as well, and consumers or borrowers. All home loan lenders, as a requirement of their license, their credit license, has to be a member of AFCA. They actually have to pay fees to do that, but it is a requirement of their license that they belong to this dispute resolution body. So using the complaint resolution scheme, this AFCA is the best way for a borrower to resolve any financial hardship complaints or disputes they have with their lender. And very importantly, the lender cannot start or continue legal action to enforce the debt, that is to take steps to actually repossess the home, while the dispute is being considered by AFCA. So in most instances, unless it's urgent, the borrower will first make a complaint through the internal dispute resolution process that the bank has to have in place. And that involves a different officer or member, employee of the bank reviewing the borrower's hardship application that's been refused, and then deciding whether that they will agree to it or whether they'll confirm that they think that it should have been refused. Then if the borrower isn't happy with that review process, then they can take it directly to the Australian Financial Complaints Authority. And mostly this is done online at the AFCA website. And as the AFCA website also lists every lender's internal dispute resolution officer. So you can do a search under Find a Member on the AFCA website to know who it is that, when you're asking for a review of the decision by the lender, who's the complaints officer that you should direct that complaint to. So that's really sort of dealing with the first part of mortgage stress, which is where people are having difficulty. They may be a bit behind, but they may be catching up, or they're just having to rearrange things, and it's difficult for them. What we're going to go to in this more or less second half of the presentation is that what happens after the loan has gone into a certain amount of arrears, and it triggers the process whereby the lender can take action to enforce the loan. So every mortgage that the borrower's entered into with the bank gives the lender the right to take possession of the home and sell it if the borrower is not making payments on the loan. Okay, so there's a series of steps that the lender has to follow before they can exercise their power of sale under the terms of the mortgage. So I'll just go on and explain those broadly, the 4 steps. that the lender has to go through to when the borrower has defaulted. That's what we call the term defaulted on their loan repayments. So they may receive, they have received, a number of communications from the lender when they're fallen behind, and then they may, make up those payments and get back on top of it again. But the most important notice from the bank is what's called a default notice under Section 88 of the credit law, and it will refer to Section 88 of the credit law in it. So they may get other default notice, but this is the most important default notice, as it is the first step in the process legally to take the house. So this notice gives the borrower 30 days to fix the default. So if they do that, if they are able to fix the default and get up to making the usual repayments, then the contract, the home loan contract, goes back to normal, and the lender can't commence legal action. If that isn't the case, so if the borrower isn't able to bring the loan back up to date, then the lender can then take the next step to make the whole loan repayable and commence legal action. So this is a crucial point in the process, and it is something that borrowers really need to take seriously, and we suggest they get both legal and financial counselling and legal advice. They can also lodge if they haven't already asked for a hardship variation, then at this stage it's probably best for them to lodge straight away in the Australian Financial Complaints Authority if they haven't already done so, because it will it'll put the brakes on the legal process, and it may be an opportunity give the borrower some time, and may bring the bank and the lender and the borrower in a position where they can negotiate to deal with the hardship variation at that stage. So the next step, this is becoming much more serious now, in terms of the next step on the path to repossession and eviction. The lender, so if they don't do anything about the default notice, if they don't lodge in AFCA, if they just ignore it, then the next step for the lender is to commence legal proceedings in the Supreme Court of New South Wales, and the court document that does that is called a statement of claim. And in that statement of claim, it will set out the terms of the contract, the fact that the borrower has not complied with those terms, and ask for the court to make an order that either the whole of the loan be repaid, and more usually also for that the lender can then get an order that they take possession of the person's home in order to exercise their power of sale under the terms of the mortgage. So, and if they are supposed to serve that statement of claim, what that means is that they have to arrange for that court document, the statement of claim, to be personally handed to the borrower to bring it to their attention. And then if the borrower then does nothing, basically the borrower has 28 days from when they receive that court document, that statement of claim, to respond by filing a defence in the court. And so that's another court document which is going to say, I don't owe the money. There's some, or there's some problems with this in terms of, what they're actually claiming is not legally what they're entitled to. Or they can also, the borrower, if they lodge a complaint with AFCA at that stage, then they can get then AFCA will they won't be able to proceed further until until that's dealt with, that complaint is dealt with in AFCA. But if the borrower does nothing, if they just ignore that statement of claim, they don't work out something with the bank, then the lender will then be able to ask the court to make a judgment in their favour, and that is the next step in the process. So if they, as I said, if they haven't gone to AFCA, if they haven't filed a defence, then they'll get that order, and then they'll be able to take the next step. Now, just to note that it's not too late to ask the bank for to make repayment arrangements after the judgment. Okay, so they can still try to negotiate a repayment arrangement with the lender, and if the lender agrees to the payment, then the borrower really needs to make sure they get that confirmed in writing. Okay, because if the borrower makes a repayment arrangement after the court's made the order, the judgment, and they miss a payment, the lender can immediately apply to get possession of their home, to get an order for possession, without any further notice to the borrower, even if they're a day late or a few cents short. It can just trigger the whole repossession process. And I've often seen it when I've talked to clients that when they come to us and they're saying, well, I didn't, I wasn't aware of this, that, and the other, and now, they're taking action to take my home. And then I discover that perhaps 12 months before, they'd been served with a statement of claim, they'd come to a repayment arrangement, but then they defaulted on that repayment arrangement. And so the bank has just gone without any further notice to take that next step to get the judgment. And so the next step, after they've got the lender has got that order, they then can get the sheriff, which is an officer who enforces court orders, civil court orders, that is, rather than criminal. The sheriff will then serve a notice to vacate on the borrower, homeowner, and then at that point, that will be where the borrower and homeowner is required to leave the property and allow the bank to take possession. The sheriff has to give the borrower a minimum of 30 days notice after the first time a notice to vacate is served on them. 30 days. So if the borrower does nothing within that 30 days, then the sheriff will come to the house and then they will evict the borrower and any other occupants of the property and change the locks, and then the bank will then take over in terms of putting the property on the market for sale, and the borrower has no further control over that process of the bank selling the property, and then it's very distressing, obviously, if borrowers leave it to this point where they take no action and then they find themselves in this position. Often we have people coming to us at this very, very late stage to get advice and help, but their options are very, very limited compared to what they would have been if earlier in the process, when they first got a default notice, they had jumped in and taken some action and tried to work something out, either to even, maybe even to sell the home rather than let it go, and up to this point. So at this stage, as I said, the borrower's options are very limited. Okay, they can attempt to get what is called a stay of the eviction. So that means that the eviction from the borrower's home, the process of eviction and the sheriff coming around, will be placed on a hold until a later date or until the stay is lifted. So the borrower might be able to apply for an extension of time for them to move out of their house, or stay all action depending on their circumstances. They must get urgent legal advice at this point, and that, you know, we are able to advise and maybe assist borrowers when they're at this crisis point. But as I said, the options are very limited. They can at first try to get the lender to agree to stay. So the lender has the power to call off the sheriff, postpone that process. But if they're not successful and the borrower doesn't agree to it, then they really should immediately lodge a complaint with the Australian Financial Complaints Authority. At this late stage, the Australian Financial Complaints Authority can't really deal with a hardship variation dispute. It's too late for that. They don't have the power to deal with that at this late stage after judgment has been made. But they can possibly get the borrower more time, get the lender to give them more time to either to sell, refinance, or to move out. Okay, so it's really important to get legal advice at this stage. Even if they lodge in AFCA, it doesn't automatically stop the eviction, especially if the eviction date is too close for AFCA to intervene and for a message to get to the sheriff that they can't take any further action until that's dealt with. If the time to vacate is only a week or less away, and we do get people contacting us at that absolute, like, seconds to midnight, then the borrower will probably is advised to make an application to the Supreme Court for a stay of eviction. And we often can assist people with that process by helping them perhaps draft some court documents that are required, and providing them with some advice about how to go about that process. And that process usually applying to the court, depending on how far down the track it is in terms of the provisions that have been made. It's applying to the court for that. It's very difficult, or if not impossible, to get the court to agree to a long-term stay of an eviction. The process is mainly used to get a stay for a few weeks, or less commonly months. So it really is, it's just about getting a little bit more time. It's not going to reverse the eviction process. It's just going to give the borrower some more time to work out what they're going to do, where they're going to live, and all those other crucial issues that they'd be facing in that terrible situation where they find that they have to leave their home. So that the documents that they need to lodge in the court is what's called an affidavit, and an affidavit is a written statement from the borrower about what their circumstances are and why they're asking for a stay, and how long they want that stay. And it is also a document, an affidavit, that they should also attach any documents that support their request. So, for example, if they are selling their home, they'd need to show that they have a contract for sale and they've got a real estate agent, and that they've listed their property for sale. If they just go in to the court and say, well, that's what they want to do, it's very unlikely, unless they've shown that they've already taken steps in that direction, that the court would grant them a stay on that basis, because they'd be saying, look, you know, if you were going to do this, you've had plenty of time to arrange this or organise this before. Or say, for example, if someone has illness, or there's certain circumstances where they have, you know, they've got people that are living with them that are elderly or infirm, and that they have carers responsibilities, and they have to make arrangements in relation to that, then they'd need sort of medical reports and other documents to support that. So it's not simply a matter of just going to the court and saying, I need more time. You know, it has to be substantiated with some evidence, and it has to be sort of a reasonable request. But as I said, at this point in the proceedings, it's really it's pretty much too late, I think, for the borrower in most circumstances to do anything to be able to continue to stay in the property. So what we've got up on our screen now is a picture of the Mortgage Stress Handbook, and this is a really excellent publication and resource that's been put together by Financial Rights Service and Legal Aid. So we recommend that you get a hold of a copy of the handbook. It deals with all the issues we've covered in this webinar in plain English, and it also includes sample letters and court documents to assist borrowers if they're trying to find their way through the maze of the whole financial hardship and various court proceedings, default, etc. It's a very hands-on, practical toolkit, really. You can download the soft copy version at the web address there that we've got on the screen. So that's the Legal Aid Publications. And you can also order hard copies, maybe multiple hard copies if you, as community workers, you know, find that you've got clients and people that may benefit from having a look at the Mortgage Stress Handbook, then you can get multiple copies and hand them out to people as you encounter them. And also, you know, on the next slide, we're just going to go to where you can go if you want to get the if you want to get your clients some legal help. And so law access seems to be like the common entry point now for contacting legal aid. So there's that number up there on your screen, and if they think that that they can give them initial information, and they can also direct them where to get help, and they can also book them an appointment with one of our legal aid solicitors where appropriate, that can then give them one-on-one advice and assistance depending on what their situation is. Borrowers can also get help with financial hardship or mortgage stress by calling the National Debt Helpline or by visiting their website. And they offer lots of options. They've also got fantastic fact sheets that cover various issues in relation to mortgage stress and financial hardship and all sorts of things in relation to credit and debt issues. They're a very excellent resource, the Financial Rights website, and they can also offer a chat with a financial counsellor, and that can be a really good starting point for people when they're really in under a lot of stress and they're needing some guidance and you know, someone that's got some experience and can sort of lead them through the process and also give them some perspective on their situation and realistically what the best way of dealing with their situation is. So keep those in mind when you're dealing with clients, and you know, you want to give them somewhere where they can get some immediate advice and assistance.
Thanks, Lee. And Annabelle has also pointed out in the comments to us that the National Debt Helpline also has a find a financial counsellor on their website. So
yes,
thanks for
good
pointing that out,
please.
Annabelle. Yes. We should add that to our slide on financial counsellors for next time. Thank you, Lee, for the presentation. We have had some questions during the presentation. So I'll just go to the first one now. Julia's asked, can you request no fees or interest is charged while account is in financial hardship? There's a follow-up question with that. Is there legal grounds for this, or is it at bank's discretion to grant this?
It's at the bank's discretion. It's not something that you, as I said, you can propose arrangements to the bank, but they have to look at them and decide what's reasonable and what's practical and what's feasible. So you don't have a right to have interest and other fees stopped. It's unlikely that essentially the lenders, they're not going to be out of pocket. Somehow that, you know, it's going to be, you'll have to pay, and it may be that, you know, there's something that's called where the arrears can be capitalized. So what that means is that, say that, you know, that you're $20,000 in arrears, the bank can agree that $20,000 in arrears can be added to the total of the loan, and then you then have to pay it out over over that period, and obviously you're kind of paying interest on it as well. So the hardship variation is really never going to be that you manage to not have to pay the bank. Yeah, they're not going to discount what you owe, essentially. Yeah. But it's something that, as I said, I mean, financial counsellors are a really good resource to talk people through what is possible, what's reasonable in terms of what they can ask for in relation to getting a hardship variation.
And I guess too, Lee, realistic, because when you sit down with a financial counsellor and you go through all your finances, it gives you that black and white view of where your situation really is. It's a great reality check, isn't it?
Yeah. I do find that it's can be that borrowers homeowners can get into a state of mind where they're just in denial about the fact that this is actually that they're in this situation where they can't continue to finance the loan, and it's a very emotional position because it's your home. It's a lot more difficult, I think, for borrowers in the home loan situation than it is, say, for someone who can't afford to pay their credit card. So we as legal advisors, as well as financial counsellors, have to have sometimes some pretty hard, difficult conversations with borrowers about whether they are really making the situation worse by not accepting reality, biting the bullet, and then maybe taking action to sell their home before the bank steps in to do it.
So I've got a question that just occurred to me when you were responding to Julia's. If you ask a bank for a hardship variation and they refuse, if you think they're being unreasonable in that, can you take that decision to internal dispute?
Yes, I'm sorry, I wasn't clear. Obviously, I wasn't clear. Yes, that's the first instance is you ask the bank for a hardship variation. If they say no, then you can ask for an internal review by another bank officer. And then if you don't, and then if that decision is not in your favour, then you have actually 2 years to lodge that complaint with AFCA. Obviously, people don't usually wait that long, but that's the time limit. You've got to do it within that 2-year period, or AFCA says it's too late. So yes, so it's a 3-step process, I suppose. One is you ask the bank for the hardship. If they say no, you ask for it to be reviewed internally. If that says no, then you lodge with AFCA, and then AFCA has to deal with the dispute. They will have to look at the reasonableness your proposal, whether it's realistic, whether whether your hardship is in fact short term, or whether it really is long term, which means that hardship variation is not appropriate in those circumstances.
Thanks, Lee. And we have another question from Michael. Upon receiving a default notice, is it worthwhile to make some partial payments even when the full account cannot be met at this time?
Yes, it is. If you can make any payments, make them, because it shows goodwill on your behalf in terms of the bank, that you're taking it seriously, you're doing what you can, and of course the more you pay, the less arrears you'll fall into, and the less interest you're going to have to pay on those arrears. So that's a really good point, Michael, I think, to make that point. If you can pay something, pay something. Until, of course, you can't work, then you have an opportunity to work something out.
So that's all the questions that we have at this stage. Does anyone else in the audience, we've got a little bit of time left. If anyone else has any other questions that they wanted to ask while we're here in the webinar, please feel free to type them into the question panel. And also just to confirm to everybody, there is an email that's sent after the webinar has finished, and we'll include the links that were provided during the presentation in that email, because it's not always easy to find the time to take down websites that are included on screen. So we'll include those in the email that is sent out about an hour after the webinar finishes. So you'll have that reference information there. Another question, Lee, are clients often successful at AFCA? Is AFCA consumer friendly?
Yes, AFCA is consumer friendly. And I believe, I mean, they are independent, but they're going to take a view of what's really reasonable, what is actually feasible in the circumstances. So if it is a proposal that on an objective look isn't going to be able to be resolved within a reasonable period of time, then AFCA will obviously make that decision that the hardship arrangement, they can't, if they disagree, so if they disagree with the lender and they find in the borrower's favour, then they can actually direct the lender to accept that repayment arrangement, and they really actually have to follow that, right? But it's important to keep in mind that under the credit law, all lenders have what we call responsible lending obligations, which means that they're not supposed to agree to arrangements where the borrower is going to be actually, if they do make the repayments they're proposing, will be in financial hardship to the point where they're not able to cover their living expenses, that they're going without food, and other issues. So that's something that AFCA would have to consider as well.
There's sort of a comment and question here. The lending contracts that banks provide seem to suggest they can terminate loans at their own discretion. Do you believe traditional lending contracts are fair in their construction?
They can't enter that. They can't terminate the loan at their own discretion. That's not right to say that. I mean, I think I've explained in the process here about the steps they have to go through. They can't just make a decision and make the loan contract immediately payable and take possession of the home. There are safeguards and steps along the way that they have to abide by before they can exercise their power of sale.
I suppose one important lesson for all of us is to be very careful when we enter into contracts like a home loan contract, to read carefully and get appropriate legal advice at that point, so you do understand the powers that you have and the obligations and the powers that the bank has if you default on your obligations.
That's right, yes. I mean, you know, it is very important to understand it, because there are, as I said, it's a two-way street. There are obligations that the bank has and obligations that you have. And it's actually, I don't know, sometimes people maybe don't really understand that the loan is what we call secured on your house. That's what a mortgage is, okay? So you can have a personal loan, right? And if you default on that, well, then the bank can try and get the money out of you and take any assets you have to sell them to repay the loan. But with a home loan and a mortgage, it is secured on the title of the property. So all properties are listed in the Land Registry Office, and the bank registers their mortgage on that title, and therefore it is secured on the home. It is their security. That's why the banks get mortgages, because they want to know that they will get their money back. And in most circumstances, it's that they know they will get their money back because the home is worth enough to cover the loan. In these circumstances where, you know, we've got pretty high property prices, then very often the bank, there won't be a shortfall. But if we enter a situation where home prices start to drop and the properties are actually worth less than they've been, that people have borrowed, there can be situations where, under certain circumstances, the bank can say, well, there's a loan value ratio, has to be a certain percentage, and but I won't get into that into detail about that at this stage. But it can be that, you know, that even impossibly we could be in a situation where a homeowner may actually not, that even the sale of the property might not cover the money that they owe, and then the bank then has to seek them for chase them for the what we call the shortfall. But that's unlikely in this current market. But it's a very uncertain time, so it's hard to know with the rise in interest rates what's going to happen to the property market. It's anybody's guess.
Thanks, Lee. So thanks to our audience for joining us today. As I said, you will receive an email following the webinar. And if there's any questions that occur to you after the webinar, feel free to send them to our CLE@legalaid.newsouthwales.gov.au email address, and we'll organise for those to be answered for you. And we really appreciate any feedback you have. There's a survey that's sent out with our email, and any suggestions or requests that you have for webinars on other legal topics, we'd be really happy to organise to have a webinar on those topics. We know the great work that community workers do, and how great you are at getting information to your clients and bringing them to legal aid or community legal centres to get advice at appropriate times. So Lee, there's lots of thank yous coming through, people saying the session was really helpful. So thank you for your time today. And
okay, and I'll just put in another plug for the Mortgage Stress Handbook. That is really, you know, it's a good resource to have, because I mean, what I went through today is it's a lot to digest. But if you've got it in a handbook, I think that's a really good resource.
And of course, the National Debt Helpline and Financial Rights Legal Service website has a lot of fabulous resources as well.
Yes, yes.
Okay, so thank you everybody, and we'll finish the webinar.